Good morning. Welcome to The Extra on KRDO News Radio. Show the connection with the topics and issues and people that are important to you. And we love talking with her every month. Catherine Hammond from the Hammond Law Group is here looking smashing as always, Catherine.
Good morning, Renee.
It's so good to see you.
It's always good to be with you.
Let's pull that just a little bit closer there. So I don't have to reach it. Oh, there we go. How are you doing?
I am fabulous.
Yeah.
Busy.
Busy's good.
Yeah, lots of people looking to get their estate planning taken care of at the beginning of the year as usual. And sometimes things slow down a little bit at the end of January into February. But seems like a lot of people are getting the message that we don't have forever to take care of our affairs.
Right. And like you said, a lot of people said it is their New Year's resolution to get it taken care of.
Absolutely. And so hopefully people are also still back at the gym, those people who made those kinds of resolutions.
Well, you and I were talking, and it's like my big resolution, which I'm still doing. I just walked by a king cake, so I'm proud of myself, was processed foods.
Good job. And it looked good.
Yes, it looked really good. I've been trying to do that. So it's been hard, but hey, we're now a month and a half in and still
Yay.
going.
Yes, and I'm doing the whole 30, which is my version of getting my body back on track. So
good for you. Sticking with it, right?
Yeah.
We both just walked by the king cake going, ha ha, although we wanted to dive in. Now, I'm sure, and we kind of talked about this briefly, with the new tax reform, I'm sure there were a lot of questions that came in about how this could possibly affect estate taxes. Does it affect it?
It does affect estate taxes. It affects income taxes, capital gains taxes, estate taxes. We are working right now on finalizing the arrangements to have a workshop specifically for our clients and friends on tax reform and exactly what it means for folks. As far as the estate taxes go, they increase the estate tax exemption for each person.
Okay.
So that now each person, when we pass away, if you pass away while this particular current law is in place, you can pass $11.2 million to the next generation tax-free. So, Renee, you still may need to worry about taxes if you have an estate over $11 million. Mm-hmm. But if you don't,
right.
If you're like most of us
that don't have an estate over
exactly, then we don't have to worry about estate taxes if we pass away while this current law is in effect. Okay. However, if you're married, that also applies to when both you and the second spouse pass away. So the thing that we know about tax law is that it changes on a regular basis.
Yes.
The estate tax exemption goes up and it goes down. Things change all the time. And so this is what's in place right now. For people who have anywhere near 10 or 11 million, you need to be doing some estate planning with tax planning included in it, no matter what they do in the future with the tax laws. If you have a smaller estate, let's say less than 5 million, let's say less than 2 million, let's say $1 million total value when you pass away, it's still really important to consider estate taxes in your estate plan, because let's say that the estate tax exemption after this law sunsets. Okay. Let's say the estate tax exemption goes back down to $1 million per person. If married couple, husband dies, leaves everything outright to wife, and they have a, let's say, $4 million estate, and then wife owns a $4 million estate. She later passes away, and the estate tax exemption is only $1 million per person.
Oh.
She now owes taxes, probably somewhere between 40 and 50% on every dollar that she was over the $1 million current exemption.
Wow.
So, still really important to do tax planning for most people.
So, and if folks have questions about that with the new tax law, and like you said, this law, right, is set to expire.
Exactly.
But if they have questions on it, they can, of course, call Hammond Law Group.
They can.
And sit down with somebody and go, help me with estate taxes.
Absolutely, yes.
Perfect.
Yes.
Well, and speaking of everybody coming in and getting their estates done, New Year's resolutions ready, that kind of brings up the top 5 myths, doesn't it, to estate planning? And I'm sure there's a lot of things that people think that aren't quite true when it comes to estate planning.
That is correct. And there are some very consistent things that people tend to think about estate planning that are completely untrue. And so
Okay.
I thought it'd be fun to debunk some of those myths
I think it's
today.
fantastic. So should we just jump right into the top 5?
Let's do it.
Okay, so what's the number 1 myth?
Number 1 myth is that if I have a will when I die, things are just going to happen that way.
So how things are is how it will happen.
Whatever I say in my will is just going to happen.
Oh, no.
That's not how it works.
No.
Right.
No.
And you know a little bit about that.
Yes, I do.
Unfortunately,
Yeah.
some of the human dynamics, just even, for the general population, one of the things that most people don't know is that having a will does not keep you out of probate. A lot of
Correct.
people come in and say, well, I have a will, so that means I won't have to go through probate, correct?
Yeah.
And I shake my head no. The word probate actually means to prove your will. And so the will is just the guide that the court uses for the probate process. What decides whether or not you're going to go through probate or your loved ones are going to go through probate when you pass away is what you own when you die. And so if you own any real estate when you die that's not currently owned in joint tenancy, then your estate will have to go through probate. So if you're a sole owner of a property, when you die, it will go through probate.
If say your significant is not, like you said, joint tenancy, right?
Exactly. So, or if you don't have a significant other.
Right.
So let's maybe go back a step. So married couple might think having it in joint tenancy will keep them out of probate. Well, yes, it would keep them out of probate when the first spouse dies, but eventually the second spouse is going to die also. And so at that time, once you're the only owner, it's going to go through probate. Now, there are there are beneficiary deeds that some people try to use to keep their house out of probate. There are some significant drawbacks to those, and if we have time at the end, we can maybe come back around to that. For a lot of people, they have drawbacks that kind of outweigh their usefulness. So one of the biggest misconceptions is that a will keeps us out of probate. It does not. If you own real estate, you still have to go through probate, even if you don't own real estate. If you have at least $66,000 worth of assets, that's your furniture, your vehicle, your art collection, your coin collection, your bank accounts that don't
Your
have
jewelry
beneficiaries,
collection,
your
yeah.
jewelry, all that stuff added up together. If that's $66,000 or more, then yes, your estate will have to go through probate.
Interesting.
Now, does it matter if your estate has to go through probate? Is a question that a lot of people ask.
Yeah.
Sometimes people will say, well, my cousin went through probate and they said that it wasn't that hard at all. So I think I don't have to worry about probate. And I would say, I've said many times before, Colorado probate is not in itself a horrible monster.
Right.
On average, it takes about 9 to 24 months. The cost that I see most people paying for attorney's fees and court fees and personal representative, everything, somewhere for a very simple, uncomplicated, unlitigated estate is somewhere between 10 and 20,000. But sometimes it's a little bit less than that. Sometimes it's substantially more if things are a little more complex or as soon as somebody starts fighting.
Yeah.
And you and I both know people start fighting.
Yes, they do. And we're going to have to take a quick break. And when we come back, we'll have more with Catherine Hammond, Hammond Law Group, Top 5 Myths of Estate Planning. It's next on The Extra on KRDO News Radio. Welcome back to The Extra on KRDO News Radio. Today we're talking the top 5 myths of estate planning with Catherine Hammond, Hammond Law Group. And we covered the first myth pretty good, like just because, there's still more to it, but we covered it pretty good. Oh.
Yeah, the other things that I think are relevant to how a will is going to make things happen are that even if you have a will, if you have other assets that have beneficiaries listed on them, those things are going to go according to your beneficiary designations.
Right.
So
yeah, that trumps the will, doesn't it?
Exactly.
Yeah.
So if you have another beneficiary on your life insurance, another beneficiary on your retirement plans, a beneficiary on your bank accounts, Those things are not going to pass under your will. They will be totally unrelated. So when you get your estate plan done, make sure that you and your lawyer are walking through all of those assets and their current ownership and beneficiary designations and coordinating those with your estate plan. And then, of course, there's joint tenancy.
Which does that lead us to myth number 2, joint tenancy?
It will lead directly in there because joint tenancy is a way that some people try to plan their estate. And so myth number 2 is that joint tenancy is the best way to hold title to my property. And there are a lot of people who think that, particularly if we're married. But also there are people who come into our office and say, yeah, I have my nephew or my daughter or whoever else as a joint tenant on my house and my bank accounts so that if something happens to me, they won't have to go through probate. It's important to understand, though, that once I have somebody else's name on my assets, whatever happens to them happens to me and my assets. So let's say your very responsible child is driving down the road in the winter, slides on the ice, and somebody else is injured or killed. I have a friend who that happened to her daughter. If that daughter, at no fault of her own, slid on the ice and gets sued, and she's a joint owner on my bank account and my house, they get my bank account and my house. Probably that's not going to happen to your family. However, divorce happens a lot.
Right.
So what happens if my wonderful daughter is a joint owner on my house, my bank accounts, my investments? She ends up getting divorced. Her now ex-husband could likely end up with 1/4 of my house, bank account, and investments.
Isn't that incredible?
Yep.
And scary.
It's very scary. So don't put anybody else onto your title of your assets as a joint owner. For blended families, there's an issue that comes up a lot. People get remarried and they buy a new house in joint tenancy and they open a bank account in joint tenancy. And their will might say that they want something to go to their children.
Right.
However, if it's all owned in joint tenancy with the new spouse, when you die, your children get completely disinherited.
Isn't that crazy?
And there's nothing that anybody can do about it.
Nothing. Even though it was
ownership. Exactly. So, even with spouses, if you're married and it's not a blended family, there are still tax drawbacks. It cuts your estate, the amount of money that you get to pass tax-free. It can cut that in half if you have it in joint tenancy with your spouse. In addition, as we already talked about, when second spouse dies, it still has to go through probate. So really, joint tenancy is not intended as an estate planning tool. It should not be used as an estate planning tool.
Because like we've talked about.
It messes things up.
I was going to say it messes things up. And we've talked about joint tenancy before. And in fact, I think we almost did a whole show on it, didn't we? Because of all the stuff that can happen. So just because, again, you're in joint tenancy does not mean said thing is going to go to that, right?
Right.
That's a little scary, isn't it? That's why we need you, Catherine. Okay, we're going to take a quick news break and we will come back and we'll finish out the top 5 myths of estate planning with Catherine Hammond, Hammond Law Group on the Extra on KRDO News Radio. Good morning and welcome back to the Extra. Today we're talking with Catherine Hammond, Hammond Law Group, and I love this. We're talking about the top 5 myths of estate planning, and it's the perfect time, as we were talking about earlier, Catherine. Lots of folks, as their New Year's resolution, getting their estate plans in place. And our first 2, just so we can recap really quick, is just because you have a will does not mean you're going to stay out of probate. And the second one is joint tenancy is the best way to hold title to property. Not true. So let's move on to myth number 3. What is myth number 3?
Myth number 3 is that I should name my children as contingent beneficiaries on my insurance policies and retirement plans. Most people think that if they're married, they should name their spouse first and their children second on retirement plans and life insurance policies. However, first of all, if your children are minors, which is under the age of 21 in Colorado, and they receive more than $10,000 in inheritance, they can't receive that until age 21. And so it gets stuck in the legal system with
Right.
lawyers and judges paying fees, and the judge decides how everything is invested and how it's spent until they turn 21. And in addition, at age 21, they're going to get a check for whatever remains. And most 21-year-olds are not great with large checks.
Right.
And the question for me is, will your children at age 21 use that money in a way that they will feel good about 10 years later? But even if your children are already adults, there are drawbacks to naming them directly as beneficiaries on those things. If they have creditors, if they have a bankruptcy, if they have a whole bunch in student loans or other creditor issues, that can make whatever you leave to them subject to their creditors. It might be like my daughters, who are 25 and 27 and responsible young ladies. They're just not very practiced with large chunks of money. They haven't had large chunks of money before. And so if I'm hit by a Mack truck and they receive a chunk of life insurance, I'm afraid that they would spend it before they have a chance to really think through how to spend it. And I want them to have some time. So the other thing is that if they get divorced, if money from my life insurance policy, from my retirement plans, goes directly to my kids, and in the future they get divorced, typically that money is going to be commingled with the rest of their marital money. They go out and buy a house together. They start a business together. All of that is going to be divided 50-50 with their future ex-husband.
So think about it before you make them like you're saying,
Absolutely.
the contingent.
Chat with your attorney.
And if you do, then maybe put some, like you're saying, some, I don't want to say precautions, but that's the best way, right?
And
in
you
place.
can pass it through a trust within your estate plan and solve all those problems.
Right. A trust can help. Okay, so myth number 4. Let's talk about myth number 4.
Oh, this is a big one.
Is it?
That a power of attorney will take care of all of my problems if I become disabled, either temporarily or permanently.
So is that just not true at all?
Not true at
all. Okay.
At all. So first of all, a power of attorney is only good for a limited period of time. Most banks will only accept it for somewhere between 1 and 5 years after you signed it. So you could sign a new one every single year, but if you become incapacitated at some point, you can't sign a new one anymore. If you stay alive much longer, then we can't sell your house. We can't take care of your banking. We can't pay your bills. We get stuck, and so we have to go to court.
Okay.
In addition, powers of attorney are not accepted by every institution. There are plenty of institutions that require that a power of attorney be on their own form. So you can have the best power of attorney in the world. It can be brand new, but if it's not on their form.
We've talked about this before, haven't we? Yeah.
In addition, it doesn't cover healthcare issues.
That's entirely separate, isn't it?
Exactly. You have to have separate healthcare directives that say who can make healthcare decisions for you if you can't communicate those.
And is that one of the biggest misconceptions with the power of attorney? Like, oh, then I'm the power of attorney. I can walk in and make those health decisions, and that's just not.
Exactly.
So,
and some people even think that a power of attorney works after we die, but it only works until we die.
See, yeah, that's crazy.
Yeah.
So then what are some of the options that you want to think about instead of possibly a power of attorney?
So typically, if you're concerned about what happens if you become incapacitated, the other more comprehensive, more long-lasting solution is a revocable living trust. The word trust makes a lot of people think that's only for people who are really wealthy, and I'm not really wealthy. But a living trust is not like the old trusts that people used to do just for wealthy people in tax planning. One of the primary benefits of a living trust is that if you become incapacitated, it allows other people to just step in and take care of things without having to go to court, in addition to keeping things out of court when you die. So if you're concerned about that, at least take the time to learn about what your options are.
Yeah, because like you're saying, I mean, everything that we've talked about with these myths, it's like, here's this, but there is this option.
Right.
To make sure you are protected, your family's protected, your spouse is protected. That's why I'm glad we're doing these top 5 myths. Okay, so let's take another quick break. And when we come back, we'll do myth number 5. And then you have upcoming workshops coming up, which we know fill up quickly. So we need to talk about those. We'll have more with Catherine Hammond, Hammond Law Group, next on The Extra on KRDO News Radio. Welcome back to the Extra. Today we're chatting with Catherine Hammond, Hammond Law Group, talking about the top 5 myths to estate planning. So let's get straight to it. So really quick, if you're just joining us, for top 4 myths so far is just because you have a will does not mean you may not end up in probate. Joint tenancy does not protect your property, basically, right, Catherine? 3, okay to possibly make your kids the contingent beneficiaries, but look at other options as well, right? 4 is the power of attorney does not solve your problems. Just because there's a power of attorney does not help with like health stuff. And remember, if somebody passes away, the power of attorney is useless.
And it doesn't work very long, even for your financial affairs.
And that brings us to number 5.
My estate isn't big enough to worry about probate or estate taxes.
Not true.
Not true. Or at least don't be so sure on the face of things. Again, if you have any real estate, you're going to go through probate. Once you die or once both you and your spouse die, there's a probate. Even if you don't own real estate, if you have $66,000 worth of stuff in your house, plus your car that doesn't have beneficiaries listed on it, or bank accounts that don't have beneficiaries, then you're going through probate. And whether or not you need to worry about estate planning and probate has more to do, I would say, with your goals than with what you own. So if you're somebody who really wants to minimize headaches for your family, if you become disabled and when you die, you need to be thinking about, should I have my family go through probate or should I look at other options? If you want to minimize costs and fees, you should be looking at this. If you want to minimize family fighting, it's pretty easy to fight in probate.
It is.
It's not as easy to fight with a revocable living trust or other probate avoidance tools. And are you concerned about helping your heirs use money wisely? So I would say the smaller your estate is, a lot of people think estate planning is only for people with lots of money. The smaller your estate is, the more precious every dollar becomes.
Yeah.
Right?
Good point.
So take good care of it.
Yes, and take good care of loved ones as well. And
Right.
and for those of us who have been locked up in court for a long time after, stuff like that, it's like, in my opinion, anything I can do to make it easier for everybody else, just do it.
Just do it.
Just do it. Okay, and you also brought a bonus myth.
I did. I don't have to do estate planning until I get old, as I pound my fist on the table. This one is so common. None of us want to deal with it. None of us want to deal with it. And we don't think that our time is going to come. 70% of Americans have no written estate plan in place. But we don't ever know what's going to happen. We all get reminders of this every single day. People have strokes. People have heart attacks. I have a friend whose wife died at age 40-something, one of the healthiest people around, went out for a daily activity that was not high stress and died of a heart issue.
Oh, my gosh.
People get in car accidents.
Yeah.
And these days, we live in a world that's dangerous. We have shootings in Colorado Springs in places where we just happen to be regularly. We see those. We've seen them way too many times over the last few years. So we don't know what's going to happen or if it's going to happen to us. If it's something that's important for you, do it now while you can, because losing a loved one is hard enough if you have all of your affairs in order.
Right.
If you don't, it makes it so much harder, and taking just a little bit of time today to get it taken care of makes a world of difference for your loved ones whenever your time comes.
Absolutely. And yeah, things can change in an instant, as everybody knows. Okay, so if people are thinking, going, okay, I need to start this process, and you usually have the, I don't want to say estate planning 101 class, but you do have a workshop kind of like that, don't you?
We do.
Yeah.
Estate Planning 101 is a great title for it, because it's the basics of wills and trusts and probates and common concerns that people have in today's world. And we do those on at least a monthly basis. So we have them coming up on Wednesday, March 7th at 2:30 in the afternoon and 6:30 in the evening over on the east side of town at Sky Sox Stadium. And then again on the morning of Saturday, March 10th in the Briargate area at 10 o'clock. those have been filling up
Quickly.
the last couple of
Yeah.
months. And so register today if you want to make sure you get into one of those. You can go online to coloradoestateplan.com or call our office at 719-520-1474.
And like you said, they're filling up quickly, so grab the date. Not that these are the only ones that you guys are doing, but
We'll do them again in April.
right. So
Get your affairs in order while you still can.
absolutely. Catherine, as always appreciate when you come in and we get you scheduled for next month. And coming up tomorrow on the Extra, we'll draw the big winner for the Louis Craft Jewelers Valentine's Day giveaway and talk with Louisa and Andrew also on the Extra tomorrow, KRDO News Radio.